Okay, I've got 4:30, so we'll go ahead and begin. I'm sure we will have several others joining us in a few moments, and I'll continue to let them into the room. My name is David Burton, and I am the Vice President for the Oklahoma Council for the Social Studies. And I want to say thank you to everyone who is joining us today for this special presentation from Gilder Lehrman Institute of American History. This is part of the Oklahoma Council for the Social Studies annual conference. This year it is a virtual conference rather than an in-person conference. And as such, we are able to reach significantly more people with this conference. I'm sure there are going to be people who are joining us from outside of Oklahoma, and we are very excited about that opportunity. At different points throughout today's session, I'm going to be dropping a link into the chat box, and it will be basically an attendance or sign-in opportunity so that you can get a professional development certificate for attending today. And again, I'll just submit that very same link multiple times in the chat box to make sure there are plenty of opportunities to fill that out. And having said that, I'm going to turn it over to Martha, and she's going to introduce the gang from Gilder Lehrman.
Thank you so much, David. And thank you everyone for being here today. And a special thank you to the Oklahoma Council for Social Studies for having us. My name is Martha. I am an education program coordinator for Gilder Lehrman. And today we are going to do Teaching Civics Through History, which is one of the professional development programs we have at Gilder Lehrman, and this topic will be on freedom of speech. So before I get into the run of the day and I introduce our lovely panel, I wanted to take this opportunity to thank the Sumners Foundation. The Sumners Foundation has funded this program and has made this possible for us. So thank you so much to the Sumners Foundation. I'm just gonna play this quick video.
We come from different walks of life and follow different paths, pursue different professions, practice different traditions. We come from different walks of life and follow different paths, pursue different professions, practice different traditions. We are different. Yet one thing unites us. We are Americans. We are the Sumners Foundation, developing a network of thought leaders around the founding ideals of self-governance by funding scholarships and investing in programs that educate and engage Americans. The Sumners Foundation, on the job since 1949.
So because of organizations like the Sumners Foundation, we are able to host these programs for you. And just a little bit of background on Gilder Lehrman, for those of you who it's your first time joining us, we are the leading nonprofit organization dedicated to K-12 history education, while also serving the general public. So we get to bring these programs to you. We have our Hamilton education program, teacher seminars, the Gilder Lehrman collection, which features a First Friday, highlighting different items from our primary source documents and materials. And we also provide direct access to teachers and students as well. Now for today's program. So before we jump into it, I want to introduce our scholar, Bruce Allen Murphy. We also have Ron Nash from the Gilder Lehrman Institute. He is our lead master teacher and will be hosting or running the pedagogy portion of this workshop. Also joining us is Zachary Macintosh, who is training to be a master teacher. He was the Michigan History Teacher of the Year this past year. So we're very excited to have him. So we will be having a 45-minute lecture from Bruce, followed by a 15-minute live Q&A for you guys to type questions into the chat for us to answer, or that we can ask for you, or we will ask you to unmute yourself so you can ask your question directly. As of right now, your microphone's automatically muted. Please keep it muted, again, unless you are called on by a moderator or a presenter. Your camera is automatically turned off, but feel free to keep your camera on. And we recommend viewing in full screen so that you can see both the speaker and the presentation at the same time. So now I'm going to kick it over to Ron Nash, who is going to walk you through a little pre-test before we get into the lecture.
Well, actually, two things. Thank you so much, Martha, and good evening, everybody, or good afternoon, depending on where you are. But yeah, I'm always excited about presenting with teachers, and today, I know virtual, you've all been challenged with this, and you're probably going to be able to help me out with some of the challenges that you've been facing as well. But I kind of wanted to set the plate two ways. One, we're kind of around a virtual Harkness table, and that's good, but that means that we participate. And I know David's already put some things in terms of a sign-in sheet, so be aware of that, sign in. The second thing is, as Martha just mentioned, and again, I always mention this at seminars. Seminars belong to you. So, Bruce is going to talk, I'm going to talk, but, we need you to talk, and we need you to think, and we'll talk a lot more about that as we go along. So, interaction, of the participants is what is going to make this 2 hours very successful. Now, I want to muse just 1 second and think back to my senior year in high school, because I'm going to set the plate for Bruce here and for all of us to start thinking. I think it's, sort of a reflection of the time. One of the plays that I read as a senior in high school, and hopefully you're familiar with it, The Man for All Seasons. I'm just going to take a chunk out of that to set the plate for the azimuth of where we want to go for the next 2 hours. And if you're not familiar with the play, I'm only going to read a section of a dialogue between Will Roper, who was sort of a contrarian and also about to be the son-in-law of Sir Thomas More, who is the Chancellor, like the Attorney General for England at the time. He's the Chancellor, the High Chancellor. He's the guy in charge of expediting, the execution of the law. Well, this may also sound a little familiar in terms of contemporary things as well. So Will Roper, like I said, a contrarian. So now you'd give the devil benefit of law. More, St. Thomas More. Yes, what would you do? Cut a great road through the law to go after and get at the devil? Roper, I'd cut down every law in England to do that. More, oh, and when the last law was down and the devil turned round on you, where would you hide, Roper? The laws all being flat. The country's planted thick with laws from coast to coast, man's laws, not God's. And if you cut them down and you're just the man to do it, you really think you could stand upright in the wind that would blow then? Yes, I'd give the devil the benefit of the law for my own safety's sake. Well, that sounds kind of like a page right out of what we're living through right now, I think. But it also sets the plate for freedom of speech. And it also sets the plate for how important the law is. And with that in mind, I know, good teaching, we're going to do a pretest. All right, so put your oil in your brain. Okay, we've got 12 questions for you to take a look at. And Martha, if you would pull them up. They're true and untrue questions. And this will give us a kind of a roadmap to what we should emphasize or not as we go for the next couple of hours. So Martha, you want to pull up our pretest?
I just dropped the link into the chat to a Google form, so please use that form to take the quiz. Thank you, everyone.
Okay, so does everybody want to click on that Google link? And like I said, there's 12 questions there. Is the statement true? Is the statement untrue? Everybody got it? And that, raise your hand if you did. It's important. when you're done, just let us know you're done.
Yeah, we'll just give a couple minutes.
And Martha, you're going to be able to tabulate that? Okay. We're getting there. I'm just
All right. Yep, they're coming in.
All right.
So we can continue on. We'll be going over these answers later on in the program. I see you all answering them. I think most of you are done. So Ron, I'll bring up that data.
Okay, we can do that in a little bit. Yeah, absolutely. That's fine. And I think it's at this moment that we should transition, with that in mind, you're thinking about these issues, is it free speech? Is it not free speech? Is it violating free speech? Is it, something else that needs to be addressed? And again, if these questions raise questions for you, that's important too. I think that as we go through the next hour, like I said, participation is everything. We're in the agora, like in the polis in Athens. Everybody needs to be able to exchange ideas. And I think if we have questions, Bruce is here. So and also for the pedagogy, we'll try to connect the material that Bruce is going to talk about to the classroom as well. So with that in mind, Professor Bruce Allen Murphy, the Kirby Chair, at the Lafayette College and an expert in constitutional law. So I'll turn that over to you, Professor Murphy.
Thank you, Ron. Thank you, Martha. Good afternoon to all of you in Oklahoma. I've never been to Oklahoma, but one day I will. It's evening here, as you know. Ron and Martha have given me 45 minutes to cover freedom of speech, and I'm objecting because that's not enough time for speech. I will do the very best I can. How many of you teach AP, history, or government? How many have we got? I'm going to go to both screens to get a sense. I have a sense that it's a fair number, and the fact that you're here and you have this interest in this topic leads me to think that the best thing that I can do in my limited amount of time is to give you as much good information as I can that you can bring into the classroom. So what I want to do is I want to try to give you some of the sort of basic backgrounds information for the topic of free speech, and then cover as much about free speech general themes as I possibly can. If I've successfully mastered the technology, you should be seeing the court ideologically arranged in 2019. Is that right? Okay, so this was your Supreme Court. You know that Ruth Bader Ginsburg is no longer there. And I want us to understand first and foremost that the First Amendment is not actually the First Amendment. It's the Third Amendment. There were two other amendments that were not adopted by the states. They dealt with the size of congressional districts, and they dealt with whether Congress could raise their own salaries as opposed to raising future congressional salaries. They were not ratified, and so we were left with the First Amendment, which, as you know, begins with the word Congress. So the conventional wisdom, the conventional understanding of the Bill of Rights is that the Bill of Rights were designed to restrict Congress. And the fear was by the states, especially the large states, that the Congress and the new national government would take over all of the governmental powers and leave the states with nothing to do. Now, the other part of the conventional wisdom is that the framers intended for total protection of free speech when they say Congress shall make no law, and Hugo Black used to make that a capital N, capital O, and multiple exclamation points. So we will be getting into that issue as well. When you look at these 9 people now replacing Amy Coney Barrett, replacing Ruth Bader Ginsburg, they are the ones who are going to decide what those words in the First Amendment mean now. And they are doing so with the understanding that generations of other groups of justices have already set the precedent for how those decisions should be made. So the question is, where will this new group go? Since 1974, the way to understand the court is to understand it according to the way that William Brennan understood it. He used to walk around the halls, he would see a law clerk, he would put 5 fingers in the air, and he would say 5. All I need to find is 5 justices, and I can do anything I want. Well, because of the increasing polarization of the American political scene, the increasing polarization of the Senate, there has been an increasing polarization and ideological fragmentation of the Supreme Court. And because of a series of episodes over that 40-year time, the court has been relatively balanced until just recently. Generally, it's been 4 justices who are generally liberal, 4 justices who are generally conservative, and then a justice in the middle who the conventional wisdom calls the swing justice, not always the swing justice. It's actually sort of the median justice or the tipping point justice. That tipping point justice right here at 0 is Chief Justice John Roberts. It's the first time that that had happened dating back to Charles Evans Hughes in the 1930s. And it wasn't a long-lasting position for Roberts. That has now changed. But Roberts succeeded Anthony Kennedy, who was the tipping point justice from 2006 to 2018. Kennedy succeeded Sandra Day O'Connor, who was the tipping point justice either from 1992 or 1994, depending on how you count, to 2006. And she learned how to do that from Lewis Powell, who was the tipping point justice from 1974 to 1987. When you look at those justices in many issue areas, the way they decided was the way that the court was going to go. And this was especially true in social issues types of cases. It was especially true in the death penalty area. It was true in many of the federalism cases as well. The major cases were determined by that individual justice in the center. When we look at the current court, my argument is going to be that you cannot predict where this court is going to go because we don't know how these justices are going to align. Generally, the most liberal justice on the far left as you're looking at this array is Sonia Sotomayor. She is quite a bit more liberal than the pair of Stephen Breyer and Elena Kagan. So those are the 3 liberals on the court. On the far right, behind all of your heads, is Clarence Thomas on the far right and Samuel Alito. So you've got a kind of a right wing on the court, and then to everybody's surprise for the moment, for the last year or two, 2 of the 3 newest justices, Brett Kavanaugh and Neil Gorsuch, have aligned very close to where John Roberts is. To give you a sense of the reference point, when you talk about the most liberal justice of all time, it's going to be William O. Douglas, who's going to be at -7. What you're looking at is the Martin Quinn scores, and they are charting the statistics of when does a justice uphold a precedent, when does a justice overturn a precedent. The justice who overturns most of the precedents is going to measure out on the liberal side. The justice who upholds most of them is going to measure out on the conservative side. So when you look at where Roberts is, to his immediate right, to your left, is where Sandra Day O'Connor was. To his immediate left, to your right, as you look at Roberts, that's where Anthony Kennedy was. So this court was more conservative than the O'Connor court and the O'Connor court was more conservative than the Lewis Powell court. The court center has been getting further to the right. What I wanted you to see was, we don't know, one, whether Kavanaugh and Gorsuch will stay close to the center or whether they will drift more to where Clarence Thomas is. And two, we have no idea where Amy Coney Barrett's going to be. She hasn't been on the court long enough. The conventional thinking was that she would be very conservative over between Samuel Alito and Clarence Thomas. My argument is it's equally possible, in fact, I think a little more likely, that she could actually align with Brett Kavanaugh and Neil Gorsuch. And the reason is, as I'm going to argue, she decides cases pretty much the same way that they decide cases. All three of them are following the legacy of the originalism of Antonin Scalia. And even though Scalia was very conservative, you can see that Gorsuch and Kavanaugh are not. So now let me do a bit of an introduction of what kind of concepts you can teach your students that will be helpful to understand cases in all areas. Number one, justices are either going to be historians or they're going to be political philosophers combined with social scientists. Historians or political philosophers combined with social scientists. The justices who are historians are following the technique originally of Robert Bork, who argued that there was an original intent that he could discern. What did the framers of the Bill of Rights, what did the framers of the Constitution mean when they wrote those words? If we could read the minds of James Madison and others and Thomas Jefferson, we would know how we should decide now in order to center and anchor the interpretation according to what the framers intended. The reason that Antonin Scalia got on the court, one of the reasons, the main reason was that Ronald Reagan wanted to put an Italian American on the Supreme Court to have a first in his appointment. But one of the main reasons that Scalia jumped to the forefront because he took the original intent brand of Robert Bork and renamed it and re-argued it. He argued, one, I will look at the meaning of the words in the document that we are interpreting, the law, the Constitution, the Bill of Rights. And I will use textualism. I will use old dictionaries. I will figure out what those words meant in the framing era back in 1787 to 1792. And two, he argued that you don't look at original intent, you look at the original public meaning. That is, if you look at the state ratifying conventions for, say, the First Amendment or the Bill of Rights, what was the understanding of the meaning of that protection in that ratifying convention? What was their original public meaning or understanding? And he called it simply originalism. Now, the problem is, how do you get that information? That's what originalists are debating about all the time. Do they go to newspapers? Do they go to journals? Do they go to the Federalist Papers? There's all kinds of debates about what you do in that search for the original public meaning. But it was Scalia's intention to try to center the meaning of the words in that period of time. Look at the context of the information. Clarence Thomas is also an originalist, but not the same kind of originalist. He looks at the Declaration of Independence. He argues that you can look at the inalienable rights in the Declaration, life, liberty, and the pursuit of happiness. By that they meant property, and so does he. If I can tie the right that you are trying to get me to protect to those three concepts, then I will understand what the framers intended for those words, but he's using the Declaration of Independence rather than the Constitution and the Bill of Rights. Not all originalists are conservatives. There are also progressives who are originalists. The so-called living originalism of Jack Balkin, writing for Yale Law School, or what is more commonly called progressive originalism. The concept here is you look at the original framing of the Constitution and what were the institutions or the rights that were created in the founding period, 1787 to 1792, and then you move forward. How has that concept changed over time? That is, what have succeeding generations of justices done to change the meaning of those words? Why is it we only have 27 amendments? Because there are so many cases that have changed the interpretation of the Bill of Rights and the Constitution. And so the idea is you don't go back to the constitutional period, you go to the earlier precedents. When you're looking at the meaning of the Second Amendment, you don't go do what Scalia does, going back to the notion of individual rights when the Second Amendment was proposed and ratified. You go back to the 1930s, Miller versus the United States, and see what William McReynolds interpreted as the Second Amendment meaning, and then you use that advanced progressive interpretation of the Second Amendment. So this progressive originalism, occasionally you will see it from people like David Souter and John Paul Stevens and Stephen Breyer. It's always good to have your students looking for ways that you can look at the Constitution, use this historical approach, and perhaps expand the meaning of those rights. This has certainly been the case in John Roberts, where he's been looking at the Fourth Amendment. He's normally quite restrictive of individual rights when there's hard evidence that the police are gathering. But if you give him a cell phone or a cell tower search or some kind of electronic search, suddenly he changes his orientation, talks about the privacies of life, talks about the writs of assistance, and is willing to expand the rights of a defendant when it's dealing with those electronic search type of techniques. As opposed to all of these types of originalists, the other group of justices, the social scientists, are going to be progressive, living, evolving constitutionalists. They are going to look at how the precedents have changed over time, and they are going to look at social science data. They're going to look at the states and federalism and what the meaning is here. They're going to look at international court decisions, especially the European Union. That would be what John Paul Stevens did. That would be what Ruth Bader Ginsburg did. That would be what Sonia Sotomayor does all the time. An example of what we're talking about from the First Amendment. I would encourage you to teach along with your school rights cases the case Brown versus Entertainment Merchant Association, EMA, 2011. Students are fascinated with this because California is trying to ban the right of minors to buy or have violent video games. And so what the court is trying to do is to say, is a video game in fact First Amendment free speech? And how much protection do you get? What makes this interesting is that the liberal side of the court is pretty unified in saying what you're looking at is something that may not quite be what you call literature. There may be, in fact, an involvement of the player in the whole game aspect of it. And it may be possible, says Stephen Breyer, that one day people will prove that violent tendencies can be encouraged by these violent video games. And so he's willing to consider a restriction on the right of minors to buy those violent video games. But on the other side, the most protective of individuals' rights is Antonin Scalia, because he sees this as no different from violent cartoons for children. He sees it as no different from Grimm's fairy tales. He sees it as no different from violent television shows that are also giving individuals under the age of 18 these sort of violent narratives. So he is totally protective of the First Amendment rights and wants people to have access to those video games. On the other hand, the other originalist who's looking at the same period of time but reading that information differently, Clarence Thomas, says, no, you've got it wrong. That what the framers intended was not to give complete protection to individual free speech to minors, because the minors were, in a sense, owned by their parents. And so anybody who wanted to get to the minors and talk to them or have them talk to other people had to work through the parents. So he is arguing that, in fact, there can be a restriction, and the restriction can be based on the ability of the parents to say what their children can buy and what their children can see and what they cannot buy and cannot see. It's well worth taking a look at, and also to kind of speculate about how many of the justices actually knew how to play the video games. Not all of them were able to do that. And you look at the argument of Samuel Alito, who's on the conservative side, but not an originalist, it's clear he's played the game. And it's clear that Stephen Breyer have played the game, and they're very troubled by the kinds of violence that they see in this narrative. So what does that mean? What it means is you can't look at this group of 9 with Amy Coney Barrett now replacing Ginsburg somewhere on the right side of the spectrum and predict what they're going to do, because it might be true, even though this is the first time in about 40 years that we have a 6-vote majority, 6 conservatives, 3 liberals. It might be true that the 6 conservatives will separate, that in fact the conservative originalists will not agree necessarily with the conservatives either on the far right of this spectrum or the conservatives who are in fact a sort of mainstream conservative. You may see disagreements, and so you might be looking at a court that could be 6-3, or it could be 2, Alito and Thomas, 4-3, with the 4 conservatives in the center banding together, or it might be 3-3-3. And you just have to watch cases over time to get a sense of how is the court breaking and how will they decide cases, and to get a majority to get 5 votes. Part 2 of this introduction. You need to be aware in the First Amendment of the levels of scrutiny of the method that justices will decide cases. Here, Martha, if you could override my sharing and bring up the memo that you will find in the material on the Google Drive. I'm just going to touch on this because most of the information is there in this memo. The argument that is made here is that when justices look at individual rights in the Bill of Rights, they have a choice in balancing out the rights of the state versus the rights of the individual, of how much protection they will provide for the individual. Now, I start at the absolute top, absolutism, and that one's simple. It was what I mentioned in Hugo Black or earlier. Congress shall make no law abridging freedom of speech. For Hugo Black and for William O. Douglas, absolutism meant that the First Amendment free speech was absolutely protected. It could not be regulated for any reason. William O. Douglas and Hugo Black wouldn't watch videos, wouldn't watch movies, they wouldn't read materials. They weren't interested in anything other than protecting the right of the author or the director to do what they wanted. Just below that is a concept called strict scrutiny. Here you have the court saying there are some rights that are so important that they need to be protected almost absolutely. In order for the state to regulate those rights, and these would be fundamental interests, or these would be suspect classes like race and nationality, in order for the state to regulate, it had to show what I call for my students, CSI. They know that from all the TV shows, compelling state interest. They had to show that this was the only possible way to achieve their goal in regulating this right. And so the court will look at the regulation and say, I want to see that this regulation is narrowly or closely tailored, and I want to know that you are protecting the individual's right of free speech, unless the state can persuade me that there is some kind of an emergency situation and that individual right needs to be overridden by the state. This is the difference between what you would see as the clear and present danger in the most extreme version, say Whitney versus California, or Brandenburg versus Ohio with imminent and lawless action and likely to produce such action, being the test that has existed since 1969. You will notice this language is actually in the incitement to insurrection article of impeachment that Congress is now going to consider tomorrow, if the news hasn't changed in the 30 minutes that I've been with you. And so what you see there is very close to absolutism if the court wants to interpret that language the way it is written, but they're using it as strict scrutiny. You can override that if the court sees what they call hate speech. It's so intimidating that it tends to demean the self-esteem or the danger for individual groups. So that's the highest level, strict scrutiny. And one of the things to watch in the free speech area is how the court over time develops their rules for when they will protect free speech at the highest level, the strict scrutiny level. And if you will watch John Roberts and watch the Supreme Court dating back to when Antonin Scalia was on the court, it's amazing how many times the conservatives are in fact strict scrutiny advocates looking to protect free speech as best they can. Can we move a little bit down now, Martha, if we possibly can? So now I want to go to the intermediate level. The intermediate level, all the way down to the red, please. What I've done is I put in some additional kind of half changes in the levels that you can use if you're doing freedom of religion. That's when they come into play. The middle level, all that does is balance interests. And it asks whether or not the right is more worth protection than not worth protection, or whether the regulation is more worth preserving than not worth preserving. They look at the personal interests and they're asking whether or not those personal interests are more important than the governmental goals in their regulation. Is the governmental goal substantially related to what they're trying to achieve? And one of the things they look at very carefully, they will come up with a rule, they will come up with an interpretation of the rule, and then they will try to decide whether or not this right that they're trying to protect is worthy of protection. Clear and present danger, as Oliver Wendell Holmes created it with Louis Brandeis, is an intermediate balancing approach. It shifts over time as they begin to look at more cases, but all it's doing is it's looking at the speech that is offered, and then it's looking at the action that will result from the speech. It is asking how close that action is to the speech itself. And it is saying, if that action is a clear and present danger, if it's close in proximity and large enough in degree to what has been said, then Holmes and Brandeis will permit it to be restricted. But if there is no link between the speech and the action, they will not permit that. And so what the court does is it balances out the interests and it looks to see whether the regulation of the state regulates the action or the conduct of people rather than lapping over into the protected speech area that the state is not supposed to be able to regulate. Okay, so that's the intermediate level. Now, if we could go to the lowest level, the reasonableness or rational basis. Whereas in the top levels, at the strict scrutiny level or absolutism, the state almost never wins and the individual almost always loses. Here at the reasonableness or rational basis level, the individual almost never wins and the state almost always wins. Because what the court is doing is it's saying, is that law reasonable? Does that law have a rational basis? Would a rational or reasonable person agree with the purpose of the law and the way the law is being implemented? And if they would, then the court will uphold it. And here you have a court that is saying we will defer to the state, we will defer to the elected officials, and we will tend to uphold these laws at all costs. And if they do not see a rational basis, or if they do not see it as being reasonable, from time to time, the court will invent their own rational basis or find out a way, they will create a way to make that law reasonable. And so that's going to lead me to the case of Paterson versus Colorado in 1907. This is the first Oliver Wendell Holmes case in the First Amendment area. Many of you may start, as I did for many years, by teaching Holmes in Schenck versus the United States in 1919. I think it's more helpful to start, in fact, in 1907, in a very unusual case that isn't really a free speech case. It's more a freedom of press case. It deals with a Colorado judge who was deciding in favor of machine politics on the Republican side. And while the trial was underway, a local editor for a local paper was printing cartoons, making it seem like the judge was part of that machine and deciding cases just as the Republican machine politicians wanted him to decide. He was so offended by this that without a trial, without a jury, he immediately hauled that editor into court and found him guilty of contempt of court. The argument was that the individual's free press rights had been restricted and the individual's freedom of speech rights had been restricted. And his argument was a simple one. He said, the framers of the First Amendment intended for no prior restraint, none, no censorship in advance. And now you have censored me. I cannot do any more cartoons. That's true. That's exactly what the framers intended. If you look at the meaning of the First Amendment as written and as discussed, they were talking about the notion of the License Act back in the Elizabethan age, and they were talking about the notion of the king being able to censor people in advance. They didn't want that. But in addition, the framers did want to uphold the possibility that after the fact, you could subsequently punish this individual and hold them guilty for what they called conduct. And there they were using John Stuart Mill and the idea of the harm principle. Maybe what you are saying is so harmful to the general public that we need to prevent you from saying it and punish you for doing so. And so Oliver Wendell Holmes had a choice. He could either go with this is censorship or this is subsequent punishment. He chose to split the difference. He chose to argue that in theory, the meaning of the First Amendment is no prior restraint. However, when I look at these cartoons at an ongoing trial, and imagining that I'm the judge in that case, I'm thinking that maybe it's going to make it more difficult for this judge to operate the court. Maybe it's going to make it more difficult for this judge to rule. Maybe it's going to make it more difficult for this judge to have respect and for having their decisions be followed. And so I'm willing to say that in this case, this is unacceptable because, and here's what he comes up with the notion of the public welfare. And he argues that in fact, in this case, what we're dealing with is an injury to the public welfare, an injury to public order. And so what Holmes says is this fellow can be put in jail because what he has put in his paper could lead to harm to the court and harm to the judicial system and the rule of law, and I can't allow it. The initial decision by Holmes is very much at the rational basis or reasonableness level and very much against the First Amendment. Now, here's where it gets really, really interesting. 12 years later, Holmes is part of the dissenting pair of Holmes and Brandeis in Schenck versus the United States. A man has leaflets and he's trying to get people not to register for the draft. He's hauled in on the Espionage Act of 1917. He's basically giving aid and comfort to the enemy. He's harming the military. He's harming the draft. And this law says you can't do that. And so they want to put him in jail for what he has said in his circular. The court has no problem with that. And they very quickly come to the conclusion, 7 of the justices say, yes, this is harmful to the country and we need to stop it. But Holmes and Brandeis come up with a concept of clear and present danger. And Holmes argues that you cannot falsely shout fire in a movie theater and cause a panic. If you do that, your speech can be banned, you can be put in jail. And he argues that you're not banning the person for the speech, you're banning the person for the action that results from the speech, and you're banning the person because the action is close in proximity to that speech. He calls this clear and present danger. If the danger that results from the speech is clear, it's close, and it's dangerous, it will be damaging to the general populace, then that individual can be put in jail. Now, you would think that what Holmes would do here is that he would look and see, well, what happened after Schenck handed out his leaflets? How many people didn't register for the draft? Turns out no one failed to register for the draft, and there was no effect. But that's not how Holmes saw it. Remember, you're coming from 1907, and you're coming from where he was in Paterson. He says, as far as I'm concerned, it's wartime. And the military says this will harm them. I will accept their point of view. It's quite possible that there could be damage. And so he upholds the conviction against Schenck. I would urge you to read and maybe to assign, if you can, for your advanced students, The Great Dissent by Thomas Healey. It's a law professor who's done some fascinating historical research about the Abrams case. Holmes will decide it's actually 5 cases, but we usually teach 4 cases in 1919. He starts with Schenck versus the United States. Then he is arguing in a case called Frowerk versus the United States, Frohwerk, about a writer and editor in Missouri. They have published in a German-speaking newspaper a series of articles against the draft and the history of the draft. They have been hauled into court on the basis of the Espionage Act. And now Holmes wants to use his clear and present danger test. He looks at this case and he says, when I look at this case, I see that there is a possibility that there could be damage to the government and damage to the military. And he argues that it's impossible to say that it might not have been found that a little breath could result in a conflagration. Just the fact that these articles are there are enough to maybe damage the draft and the military and the war effort. And so he upholds the conviction without any proof that anybody even read the articles or did anything other than put it into a parakeet cage. Then there is an additional case, Debs versus the United States. Eugene Debs, the great socialist who ran for president so many times, gives a speech to the Socialist Convention. It is a pro-socialist party speech. However, a month before, he had signed a critique of the United States military draft. And there was some veiled language in his speech to the Socialist Convention, seeming to be critical and more sympathetic for the poor person who was drafted and sacrifices their life for the country in the war effort. It was interpreted by the US attorneys in the area as being a violation of the Espionage Act, and Debs was hauled into court, and he was found guilty. 7 justices said there's a clear and present danger that we see. He's going to jail and staying there. And Holmes and Brandeis said, well, when I look at this, I see something a little bit different. What I see is, you could ask, what was the intent of what he said? You could ask whether there is a natural tendency and reasonably probable effect of damaging the military. Holmes is still in his pro-government regulation mood, and so he too upholds this conviction. And it's at that point, somewhere in that period of time, that Holmes has left for a vacation up in Boston, Massachusetts, at his farm in Beverly, Massachusetts. As luck would happen, he was on the same train as Learned Hand of the Third Circuit Court, who was on the same train going to his cottage in Cornish, New Hampshire. Learned Hand, who was only a district court judge at that time, he would become a great Court of Appeals judge. Learned Hand has argued in a case called the Masses case. He had argued similarly to what happened in Paterson versus Colorado. You had a series of cartoons that were critical of the draft and the military and the war effort. And it was part of a sort of socialist encyclical that was put out by this newspaper. And Holmes looked at that and said, I can't do what, Hand looked at that and said, I can't do what Holmes has done. I have to have tolerance. I have to look at what those cartoons do. And I have to ask, was there an incitement by people to undercut the government? And so Learned Hand disagrees with Holmes, and he decides in favor of the publisher. I'm going to protect the right of free speech because we have to tolerate other ideas. We have to tolerate criticism of the government unless you can prove a direct link between the speech and the press and the results of the speech and the action. Well, Learned Hand sees Oliver Wendell Holmes. Each of them has read the other opinions, and Learned Hand says, basically, I wish you would give more tolerance to these people who are critical of the government. And Oliver Wendell Holmes is not willing to hear that argument. and they part from the train. A while later, Learned Hand tries again and writes Holmes a letter and says, basically, how do you know that we're right? How do you know that we're the saints and the dissenters are the sinners? Would it be possible that the saints are in fact the dissenters and we are the sinners? Could we be wrong about this war effort? Don't we as judges have to give a little more leeway to the person's freedom of speech? Holmes changes his mind in Abrams versus the United States, and that's what the Great Dissent book is all about. He has been lobbied by progressives such as Harold Lasky and Felix Frankfurter, and he argues now that what you see with a fellow who is arguing in revolutionary Russia, hoping for a mass strike in the United States by the workers to support the workers in the revolution, and has no effect on anybody in doing that. He argues that there should be a kind of free marketplace of ideas. We need to protect an individual's right to put an idea out there and see if it would be tested in the marketplace of ideas and see if it would be adopted. Furthermore, he says these are poor and puny anonymities. They need to be protected. And so Holmes has laid down the marker and completely changed his approach. And he's now arguing there might be a way to protect these dissenters. Before I talk to my students about Brandenburg versus Ohio in 1969, I show them the difference between Whitney versus California in 1928 and Dennis versus the United States in 1951. And I show them that when you're dealing with Charlotte Whitney in 1928 and whether or not she can be a member of the socialist movement in California, and whether or not it will be possible for an individual to just be a member of an organization, the court has no trouble in saying, we need to protect California. This speech has a bad tendency. Just the fact that it is offered, just the fact that the California legislature has banned it is enough for us. We are going to uphold the conviction. But Holmes and Brandeis look at Abrams and say, let me now tell you what this clear and present danger actually means. They say what we need to see is imminence. We need to see an immediate kind of reaction that is harmful to the state. We need to see that this is very serious behavior. We do not want to be like the Salem witch trials. Men feared witches and so they burnt women. We want to have a free marketplace of ideas. And so they argue, the test that we understand clear and present danger to be now is that when you say something, was there no opportunity for full discussion? If there was no time to discuss whether this is a good idea or a bad idea, whether it's true or it's false, then we will shut down the speech. But if there is any time, we will uphold it. It's as close as you will see to an absolutist standard, much beyond strict scrutiny. And the opposite of that is what happens in Dennis versus the United States. But what I want you to consider is not what the Supreme Court does. That's very interesting to analyze, where they're very pro-Congress and pro-Smith Act. I want you to consider what then Court of Appeals Judge Learned Hand does. He actually goes back to his test from the Masses case. His test there was, when I see speech, I want to look at the gravity of the evil that is being talked about. If the evil is grave, I will allow it to be restricted. But if the evil that is talked about is not grave, I will not allow that speech to be restricted. Now, in 1917, he said, though the evil is grave, it's not so grave that I'm going to shut down these cartoons. But in 1951, when he's dealing with the American Communist Party, which he says is linked to the International Communist Party, and when he considers that what the communists want to do is overthrow the government of the United States, that's a grave threat. He sees that as an infinite level of danger. And so his version of gravity of the evil is shut the speech down. He has become Oliver Wendell Holmes in 1907 and 1919. Holmes, however, in 1928, had become much different and was more like Learned Hand was when he started out. So that was the choice that the Supreme Court had in Dennis, and they chose Learned Hand. This is your test, gravity of the evil. We see that the evil is grave. We're going to shut down the speech. But in Dissent, you have William O. Douglas, who's arguing the classic Whitney versus California, original Oliver Wendell Holmes version of clear and present danger. He sent his law clerk into all of the files and he said, tell me, what did they do? Tell me the 11 leaders of the American Communist Party, where was the threat? And the clerk came back and said, I don't see much of one. And so Douglas said, I will go through the material. And he went through it and he went back to the clerk and he said, I agree with you. All they were doing was teaching. They were teaching 4 books on communism by Marx and Engels. That's not a threat. And so he argues in his dissent, if you shut down this speech, it is the worst 5th column movement in history. All they're doing is teaching theory. I need to see actual link to some kind of action that will threaten the government. They should be using clear and present danger. All of that leads to Brandenburg versus Ohio. And I know we're running short of time. Many of you probably teach this case. Here you're dealing with a film, actually then a video, of a Ku Klux Klan rally on a backwoods farm in Cincinnati, Ohio. That becomes very important. And we're talking about the Ohio criminal syndicalism. You cannot say things, you cannot do things, you cannot organize for the purpose of overthrowing the government of Ohio. And so there is a reporter and that person films this gathering, and guns are brandished and a cross is burned and terrible things are said. And when it comes to the Supreme Court, and it's right at the end of Abe Fortas's time on the court. In fact, the early draft of this per curiam opinion was written by Abe Fortas, but he was off the court. He had resigned before the opinion was issued. And so it was rewritten somewhat by William Brennan. What they did is go past what was happening in Dennis versus the United States, and they went to the Whitney case. And they said, our test now is not clear and present danger. It is 2 parts, imminent and lawless action and likely to produce such action. I want to see an immediate impact from that speech as to the danger to the government or society. And I want you to prove to me that it is extremely probable that that's going to happen. And the way that they deal with this case, it's 2 parts. One part is this gathering was in Cincinnati, but the actual government is in Columbus, Ohio, and Columbus had not been attacked and had not been overturned. So they don't see the connection between speech and the action. But another part, which is important in the facts, is that film, the video, had been put in the drawer of the editor for several days. So there was a gap of time between the speech and the action of the Ku Klux Klan and playing it on the air. And so as far as the court was concerned, there was no real danger. This is the kind of thing that John Roberts grapples with. And when you look at him in the Snyder versus Phelps case with the Westboro Baptists and their protests at military funerals, that becomes a very interesting discussion of whether or not there is a clear and present danger there, whether there's imminent and lawless action. And as far as Roberts is concerned, he's very pro free speech, almost an absolutist. He says you had a permit, this is a public issue that are on your signs, and you were protesting with that permit in a public space, a public park. I'm going to support it. But in Dissent, Samuel Alito says, no, no, no. The purpose of what they're doing is to diminish the esteem of Mr. Snyder's family, to make them feel poorly. It's an attack on this fallen hero. It's an attack on the family. I am going to declare that this is a tort. It's an intentional infliction of emotional distress. I will use bad tendency as my test, and I will shut this speech down. If you take these concepts and keep bringing the students back to this idea of how do I understand getting to 5? and you bring the students back to the notion of, are these justices following history, or are they doing social science research? Are they updating the Constitution according to the precedents? And then you teach them the levels of scrutiny so they understand how the justices are putting their thumb on the balance of rights versus state regulation. In time, you're teaching them the tools so that they can analyze these cases themselves. And then they can watch how the justices do it and figure out in their own fashion how they can predict what the court will do in the future. It's a great topic to teach. I'm really looking forward to it. I teach free speech in the spring, and so I'm getting my Zoom class ready. And I thank you all for looking at my beta test of my first lecture.
Well, thank you so much.
Thank you
Bruce.
so much.
I guess at this point, I'm looking. I thought we would have more questions, but that's a start. I mean, as we ask, we have three folks in the chat who have put some questions there, and I'll, if you, Manny, good evening, good to see you. You have a question, and I don't know if you want to unmute or do you want me to ask it? Either way is fine. So.
I'm okay with either way, Ron. A student was asking about last Wednesday, and his question was,
down, I'ma suck dick, giving head now, and my sister trying to trigger.
oops.
Try again, Manuel.
Excuse me?
Try again. I didn't get
Okay.
that.
So a student was asking today about last Wednesday's incident at the Capitol. And after the incident, we know that social media is looking at censoring the president or kicking him out from using all of that media. Does that infringe upon the president's free speech? Is this something that is legal? Are we going down a slippery slope if we start censoring social media now?
Okay, this is a very good question. I want to actually expand your question. I was sort of anticipating that this would happen. There's two parts to this question in terms of teaching. One part is the actual incident itself and the freedom of assembly and freedom to protest. And I have some other materials that I think what I'll do is give to Ron and to Martha so they can put them on your Google Drive so you can work with them. When you look at the incident on January 6th, it is not like anything we have seen to this point. What I've been doing, and I'm sort of building this as a discussion point with my own class, I've been asking them initially to look at protests in colleges, on college campuses like Berkeley and Middlebury College. Then we look at the Battle of Charlottesville. Then we look at the COVID lockdown protests, especially in Michigan. Then, and we haven't gotten there yet because it's happened so recently, there are the Black Lives Matter protests and Lafayette Square, and finally January 6th. And so what the court is going to do is it's going to look at those incidents, and it's going to look at the constitutional level of protection for free speech, what I've just been talking to you about, but it's going to use a case called Chapinski versus New Hampshire, dealing with a Jehovah's Witnesses who so offends a policeman that the policeman thinks about hitting him. And a very liberal justice at the time in 1941, Frank Murphy, says, I've got a very simple approach here, 2 levels of protection. If it is speech that you've done, it is protected. If it is conduct, it can be regulated. So all I'm going to determine is what you did to that police officer, is that speech or conduct? And he invents the concept of fighting words. He says, I am instructed by the highly trained policeman that he wanted to hit you, that you've gone too far, that was conduct, because he should not want to hit you. He should want to de-escalate and he should listen to you. And so he is arguing that speech is protected and conduct is not. And what the court has done in the assembly and protest area is to come up with a way to kind of judge that for groups of people who are trying to express their views either orally or through symbolic means or through signage or whatever. And what they do is they look at the Constitution, then they look at the law itself, how does it regulate what happened here, and then they look at the actual facts. What actually happened? Tell me what happened. Think about what you saw in Michigan, where you had protesters with automatic weapons in the Capitol in Lansing. Then you had defenders in the Capitol in Lansing, also with automatic weapons, but no shots were fired, and there were speakers outside who were talking, who were protesting. Compare that to what we saw on January 6th. So what the court would do is they would go into that episode and they would look at, okay, what precipitated this episode? What was on Twitter? What was said? Now, what did the crowd do? Now let's look at it from the standpoint of the protesters. Let's look at it from the standpoint of how did the audience react? And let's look at it from the standpoint of the police. What did they see and what did they do? It's a marvelous example of how you can take basically that group of cases I just gave you, the Chapinski concept, and about 3 assembly protest cases, Feiner versus New York, Terminiello versus Chicago, Adderley versus Florida. And the students can work this out themselves and figure out what they can do here. But part of this is the social media aspect. And I would encourage you to take a look at a case that is being considered for an appeal to the Supreme Court. It's Mahoney School District versus B.L. It's a Pennsylvania case, Third Circuit Court of Opinion, Mahonay v. B.L. If you look it up on Google, you'll find it very quickly. It deals with a cheerleader who wasn't selected for the squad. She's very angry, so she goes on Snapchat. She says a bunch of things. They are interpreted as being vulgar, and she is suspended for what she puts on Snapchat. That is a school First Amendment case. Does Tinker versus Des Moines School District apply to that? What you're asking is, can Twitter, Instagram, any of these social media, can they shut off President Trump's access to their platform? Yes, they're a private business. It's that simple. Now, if the law changes and if Congress wants to consider these a lot like utilities and make them a little more public, or if the court wants to change that view, they can change the view, I suppose, but there would be quite a battle. When you have a private business entity, they set the rules for how you operate. That thing that you click on when you want to get on Twitter, do you agree to this? It's 12 pages of single space, very small font that no one ever reads. That's part of the rules of engagement for Twitter. So in a sense, the question that you're asking about how much can Twitter do to stop this is just part of the larger issue of, well, if Twitter doesn't stop it, and people are using these platforms to instigate these kinds of episodes, then it gets us into the aspect of the Bill of Rights and governmental control and so forth. Court has not decided this at all. It's the Wild West when you're teaching. It used to be that anytime I wanted to come up with a question for an exam, I would just add the word computer. Then I would just add the word internet. Now I'm just going to add the word social media app. And it's a whole range of new questions that until the court issues some decisions in this area, we just don't know. So I would look at that cheerleader case, which would be very accessible to the students. And then you can begin discussing, okay, now that's one thing. She's mad that she's not getting to be a cheerleader. And she said some things on social media. But now let's make it national security. Now let's make it the kind of protests that we can talk about. Now what do we do? How does this change the whole issue?
Okay, thank you. I mean, again, I know we discussed that case the other day, and I guess, you know, it's resonated with, I'm just looking, I see Zach, you used it in class as well. So anyway, that is a definitely relevant case for folks that are, you know, teaching and some of the students that use social media in whatever ways that they do in your class. Lucy, I think you have a question about a case called Bostock versus Clayton County. Did you want to unmute or?
Yes, give me just 1 second.
Sure.
Hi there.
Hi,
I'm
Lucy.
a Sumner scholar. They invited us to come and watch this lecture.
Great.
And in June, the case of Bostock v. Clayton County came out that essentially forbade people from firing employees on the basis of sexual orientation.
Yeah.
Do you think that made sexual orientation an immutable characteristic in the eyes of the court?
Oh, that's a great question, and that's the way to ask it. Can you predict for me how Amy Coney Barrett will decide? Because that's the answer to it. This is a very, very interesting case question. It's very much up in the air. When you look at the way that Neil Gorsuch decided that case, that is not the way the Federalist Society predicted he would do it. That's not the way a lot of originalists and conservatives thought that he would do it. He is using his version of textualism. I am going to look at the Civil Rights Act. I'm going to look at the meaning of the word sex. I'm going to ask whether or not, even though Congress never thought about transgender rights, even though Congress never thought about the kind of same-sex rights that we're talking about here, does my reading of those words tell me I need to protect those individuals? And his answer is yes. So for the whole summer, originalists, Federalist Society people were debating furiously, did Gorsuch use Scalia's approach correctly? Guess what? He has the robe and he had the majority. The real question there, Lucy, is John Roberts signed on to his opinion, and John Roberts was in virulent dissent in Obergefell versus Hodges and Windsor versus the United States dealing with same-sex marriage. So where is John Roberts on this question? And then we have no idea who Amy Coney Barrett, how she will decide. What is her version of textualism? What is her version of originalism? You've actually framed probably an excellent question for the AP history test. That basically just watch the students try to work their way around. This is where I think Roberts is going to go. This is where whether I think Gorsuch is going to stay in this position. This is where I think Amy Coney Barrett is going to go. You can't predict because all you have to do is figure out of those 9 human beings, where are the 5 votes? Does it make it an immutable characteristic? No, I don't think so, because even in the affirmative action area, they have not been using that language, immutable characteristic. And I keep thinking if it was an immutable characteristic, you should have strict scrutiny for women's rights. That's what Lewis Powell meant, but we don't see that. So you're tying in the affirmative action area with the whole idea of civil rights and the idea of same-sex transgender rights, and it's a dissertation. It's a comprehensive exam question for a PhD student. I don't know the answer, but I will be watching intensely because I really want to see how they work their way around this problem.
Can I ask a follow-up?
Sure.
You mentioned looking at the definition of sex in order to determine the answer to that question.
Yeah.
I might have misread the brief, but didn't they decline to prove a distinction between gender and sexual orientation?
Yeah, they did. Yeah, they did. But it doesn't matter if Gorsuch puts it in his opinion and gets 4 justices to sign on to it. That was one of the arguments. You shouldn't have even done this. This wasn't even an issue. Why did you do it? Well, when you put people on the court, there's no court above them. And so we can't know the human nature of why is it that Kavanaugh and Gorsuch are so close to where John Roberts is? That's a surprise. And we can't know what Amy Coney Barrett is going to do and how she will see this. These are human beings, and they're going to bring all of their experience and all of their training and all of their study and all of the cases that they have decided, and they will rule. And our system is such that if you can get 5 justices to say, I'm not even going to listen to your brief is simply something that I may or may not read, but I'm going to decide this case. And that's really what Gorsuch is saying. All I have to do is read the law. All I have to do is read that paragraph and that clause of a sentence. I know how to determine this. You cannot have a law that that allows for harming of individuals when you have a decision that is being made that affects gender, and gender is linked to the word sex. That's how I interpret it. John Roberts is with me. The three liberals are with me. We're done. It's the politics of the court. It's the fun of it. You look at them as politicians. I teach a course on judicial biography. So what was it about Neil Gorsuch at this point in his life, having been on the court 1 year longer than Brett Kavanaugh, that said, I'm going to plant my flag and I'm going to say, watch me. I'm the new Scalia. I foresee a kind of competition among the three of them. Who is the most like Scalia? Who will we be talking about 20 years from now as the leader of the originalism movement? Thomas thinks it's him. One of these people may think it's them.
Okay, thank you.
Okay, I think one more question and then we'll go, if that's okay. Louis, I see you put a couple things in there. So are you still with us? Lou Bonds. Oh, yeah, I see it. Okay,
Yes,
there you go. Okay.
I did not ask a question. I'm listening. I'm still back at the last
Oh,
one.
not Lois, Louis.
No, I think
Lou Bonsteel, I think I saw two questions that you put in the chat.
Louis.
Maybe Louis. All right, I'll
okay.
ask the question. Louis, if you're not unmuting, that's okay. So the question that was posed, and then if you want to have a follow-up, Louis, it's I guess it's sort of a rhetorical question, but if you want to address this, tell me or not, Bruce. So motivating people to storm the Capitol, would that be clear and present danger?
It's a very interesting question, because here's how I don't know the answer to how the argument would be framed. But I want to combine it with Manuel's question, because if you look at what the president says, just what he says, it would be possible for him to say, this is not what I intended. You could make an argument on either side. If you look at what the president says in the context of Rudy Giuliani and Don Jr. speaking at the same time, and the nature of the audience, the protesters there, it might be harder for the president to make that argument. If you look at what the president says in the context of the protesters are there, Rudy Giuliani and Don Jr. have spoken, and the history of what the president has said leading up to that event, come to Washington for January 6th, it's going to be wild. And then looking at it in the context of all the things that he has said on Twitter, going back to, how far back do you want to go? 2016, 2015, before that? If that's the argument that you're making, then you may say, hey, this is a little bit like Debs. I'm going to look at what he said, but I'm going to interpret what he meant from what he said going on to that. I think this one's an easy call, because when he finished, they turned and they walked 1.5 miles down the street, and we saw on television what they did. So I think that it would be very possible to make an argument that even under Brandenburg versus Ohio, this might be what you mean by imminent and lawless action. But, and this is sort of beyond my field, is the president immune because he's a public official? Is he immune from that kind of argument? Or can he say, no, this was rhetorical? It is clearly, again, the question that I want to ask my students. Hopefully they don't see this, because they'll know what their term papers are going to be and what their final exam questions are going to be.
Thank you. That pretty much covers it. And that the question would be also, so you right at the end you said, would he be, because he's president, is he protected? but he's not president too much longer.
Yeah, and that's a very good point, because that's the argument that would be made. There are other ways to other recourse, and that part of that recourse is what we are seeing right now. That's what the incitement to insurrection is. The argument would be by the president's lawyers, the recourse is political. If you don't like what he said, impeach him. Well, that's what they're doing. That's what they're talking about. And so it really is, there's a lot of politics involved in this as well. But this notion of saying these things and seeing the reaction of the crowd and what they do, I can now talk to my students about, this is what imminent and lawless action might mean. When you're dealing with the protest at Middlebury, when there is a reaction to Charles Murray being on the stage, and the students are turning their back to him and they are reading from a script, objecting to what he's saying. There's a big difference in this timeline. I think part of what the court does is it looks at a timeline of this speech event. And once those students start to pull fire alarms because they don't want this professor to be speaking on the radio, and then they chase the professor and the professor from Middlebury as they're going to their car, and then they surround the car and threaten to tip the car over. At some point in there, you're not dealing with speech. And so the court would look at what happened on January 6th, and they would say, is there a point in this timeline that we think we have gone beyond protected speech, where there is a social worth, where there should be protection, and now we're into conduct that can be regulated? And so that's really what the argument would be, Lewis. Is there conduct, and is the recourse, in fact, a political recourse of impeachment?
Great. Thank you very much.
My pleasure. Thank you very much.
Thank you. Martha, can you pull up the results of the pretest?
Yes, so I have the results here, and it looks like most of you did very well on it. The average score was 10 out of 12 questions answered correctly. So good job, everyone. The most frequently, the question that was that most of you answered incorrectly was actually question 2, whether or not freedom of speech includes the right to burn draft cards as an anti-war protest. And sorry, I'm just scrolling down. I'm just not going to share the screen in case people don't want to, because it has individual answers.
All right,
but yeah, if you want to know specifically how many people got it right and wrong per question, just let me know, and I have that number.
All right, we can share that later. And I guess, if you thought, your answer was correct, you may want to frame a question, because I think I'd like to thank Bruce very much for, what he's just provided to us in terms of a drill down into the specific case. We're going to talk a little bit more, and he's decided to stick around with us for the rest of the time, which is great, because he also did contribute to the pedagogy, which we're going to talk about. So I think that's important as well. So if something comes up, that you want to frame as a question, we'll come back to that. And like I said, he'll, thank you again, Bruce, for your presentation. And then if there are things, raise your hand if you think there's a question that pops in your mind as we talk about some of the pedagogical content. So at this point, I'm going to do 2 things. 3. I may add to that list in a second. One, I want to share my screen for just a second, to show you where we're going. And Martha, you're going to also help us out with putting the actual lesson plan that we're going to talk about. And then I'm going to pull a couple of things from it, and we'll kind of unpack the lesson plan as we go along. And anyway, we're on hopefully everybody sees the Gilder Lehrman site here. And I just want to show you eventually, this preview of coming attractions, I guess. All right. So I'm going to click on history resources. All right. Just to show you where we're going. And then when you get this, access that Martha's going to provide, I guess by next Tuesday or so, something like that, you're going to go for the curriculum. okay? And when you go to the curriculum, I'm scrolling down, and there we are. That's what we're talking about, teaching civics through history, all right? So I'm going to just kind of tease you a little bit here, all right? So this is a whole website devoted to resources. And again, I always tell people, you know, Gilder Lehrman at the base is a resource provider, okay? So we're going to hopefully provide you, we've already started through Bruce's lecture to provide you with some of the resources and some of the suggestions that you could take back to your classroom. And again, just a, you know, quick overview. This is, you know, the program itself. And I'm going to unpack a couple words here in a second, you know, civics and history in particular. And then you can see, you know, we have 4 particular areas that we've developed. We're not going to go into any other ones except for freedom of speech, but and I'm going to give a shout out to my colleague, John McNamara, who's been here and, you know, a collaborator with me in helping to develop, you know, curriculum in race and relations, voting rights, immigration. Well, we're going to do free speech. And I'm going to, you know, do a little bit of teasing here, a little bit again, just to show you where we're headed. Then we're going to go and unpack a lesson plan. And then prior to that, actually, we're going to talk a little bit about teaching thinking, you know, as part of the whole rationale for what we're doing here. But again, you can see there's a lesson plan. That's the one that Martha's going to put into your Google, and you can see that right now in the chat. You know, there's a rubric, and I'll explain why you would want that rubric as we go along. There's an extensive timeline, again, which will be available to you with many of the things that are both in the lesson plan and which Bruce has also alluded to. Many of the cases, you know, that are in the lesson plan, we've only focused on maybe 10. There's a lot more to free speech, and there's a whole bunch of things here that are part of the, you know, the timeline where you can also have your students work with this as well. And I'm just going to show one last thing, and then we're going to unpack a couple of things. So all the way down, you know, right to the present and to this, okay? There's an interactive, and I'm just going to kind of tease you with it. I mean, you'll have access. We don't have time to go through here, but you know, freedom of speech involves political speech, and Bruce has alluded to that. Press regulation, First Amendment levels of protection, you know, First Amendment rights for minors to include students, times, places, manners, protest speech, a couple of which we are going to unpack and at least direct your attention to. Symbolic speech, obscenities, you know, there's a couple things we'll talk about, but I'll be careful of my speech. And then, you know, campaign, corporate speech, and hate speech. You know, so there, if you look into any one of these things, I'll just pick this one, for example. And there it is, Chapinski. We're going to come back to that. And I'll stress a couple of things that are actually in the lesson plan. But there are other cases here, and each one of these things, you know, Brandenburg is in the lesson plan. Some of these other things are not. But I mean, if you take a look, you know, who's on the court, what their actual decision was, when the decision took place, you know, what the background was. You know, Bruce explained about the religious nature of this, you know, confrontation, which led to fighting words being defined as something important for free speech. You know, the issue that was involved, the decision, and the significance of the case. Well, again, I'm just kind of teasing you a little bit here because there's a lot more that obviously, you know, as resources, you'll be able to take away from where we're going. So at this point, what I want to do is just click out of here. And Martha, if you would pull up the first of the 2 presentations, and I'll try to keep this to a brief period of time. But it's the rationale. Why did we do what we did in creating teaching literacy through history? So again, if you could pull up that first set of slides. Whoops. Here we go. Are we missing something? I think that's whoop, we want to go to the first one. There we go, right there. Okay, so, and again, I put a little simplistic chart, but I think it also addressed some of the things that Bruce was talking about. You know, has the government censored, fined, or imprisoned you for something you said? And again, you can take this for what it's worth. You could probably add a few things in here as well. You could probably put in private school versus public school, but again, the yes and no answers are somewhat simplistic, but again, it gets your students thinking about some of the issues. And again, what the intent of the next few slides I'm going to look at, teaching freedom of speech in terms of, if you can go to the next slide. Yeah, just a framework for why, John McNamara and myself did what we did in the creation of the lesson plan we're going to look at and the other lesson plans that are in TCTH. And also, and again, if someone stop me, if you're not sure what I'm talking about when I say TCTH or TLTH, raise your hand, ask the question, because I want to make sure everybody's with me, when we're going forward. These two, acronyms are the signature professional development programs that Gilder Lehrman has been, developing and applying for the last several years. Okay, it started out probably in 2014 when we launched this concept of teaching literacy through history, and we'll talk about that because TLTH is embedded in TCTH, except we're talking about civics and history. Let me take 1 second, all right? And I normally would do this a lot more involved in terms of this particular framework that I'm going to set up in a second here. History, teaching point, and there's a few people in the audience who probably heard this more than once, all right? History, from the Greek root, historia, meaning inquiry, questions, okay? And you can see the first line here, strategies for effective teaching, involves essential questions, all right? Obviously, tied to essential questions, you can't ask a question without looking for evidence. That's where the primary sources come in. The graphic organizers, we'll see in a second, and then obviously tied to specific literacy skills, reading skills, writing skills, speaking skills. That's all the framework that motivated us to put this particular program together. Okay, next slide. So, again, like everything else, how are facts and historical information transformed into something where students actually find value and meaning, by way of knowledge and understanding? I mean, you could say, well, whatever it might be, but again, let's go back to the question, and you'll see in a second, that in this particular unit, that there are going to be lots of facts, lots of information, but you've got to tie it to some kind of activity. And that's where obviously the knowledge and understanding for your students is going to, be the end result. No, so next slide, please. All right, so again, question, think, engage, interest, learn, okay? Well, again, I'm going to go kind of quickly on this, but it's important just as a framework, everything, if you notice, there's a kind of theme here. Question, question, question. I'll go back to that word history, historia, question, inquiry, all right? If you don't ask a question, and it's not like, when did Columbus come to America? Was it 1492 or that's not an essential question, okay? And we'll get to that in a second. An essential question, is a lot more complicated, has many different answers, but again, as a question, it's forcing you to think, it's forcing you to be engaged, it's forcing you to be interested in what we're doing, and obviously, all of those things lead to learning. Okay, next slide, please. Okay, good. All right, that's okay. So again, this is, kind of a repeat of something that I previously said, so we can go to the next slide. But let's do the teaching for thinking, transforming information. And I just want to stop for a second, essential questions. And we're going to get to these in a second, but I just want to make sure, and because I'm going to unpack the lesson plan. So for example, we've dealt with some of these essential questions as, Bruce was talking and as some people were asking questions, but, in the lesson plan, to what extent should there be government restrictions and regulations on free speech? Well, it seems like a simple question, but obviously, pretty complicated unless you understand the way that the original, and again, we're using that word original, the framework, the simple framework of what the First Amendment says, and then the fact of how the First Amendment was applied, during the 19th century, not so much at the state level, all right? It really wasn't defined. And Bruce, if you feel like you're jumping in here, we'll get to some of this too. But the history of the First Amendment really doesn't flourish until, after the turn of the 20th century. And then a number of cases that are going to take place, in terms of questions and frameworks that expand on what exactly free speech is or what it isn't. All right. To what extent can speech that encourages illegal conduct or lawless action be regulated or restricted by the government? Well, we've asked some of those questions today, in terms of, and I'm sure that there's other questions that you want to ask, and that's fine. Please do that, as we go along. But again, planning the question, the questions that we framed, that John and I framed, I'm counting 1, 2, 3, 4, there's 6 or 7 questions that formulate, with this lesson plan. These are only suggestions. You can make your own essential questions. You can develop essential questions that go beyond, this, or that relate to something that's more contemporary as things develop, either with that cheerleader case or with the president's case or with the social media platforms. I mean, there's all kinds of ways to, expand and develop questions that are most appropriate for what you're talking about in class. The primary sources we'll get to in a second, the graphic organizers we'll get to in a second. And then again, obviously, the bottom line, can students be encouraged to read better, read well, get something out of the reading, that they're doing, and then also, think through. I mean, there are wrong answers. That's the other part of the story. And you can jump in at any time when I just made that statement, just because somebody says something doesn't make it, a plausible answer. Just like 2 + 2 is 4 in math, somebody saying something in a framework, without evidence. That's the point. That's what I want to make sure everybody understands. If you say something without evidence, I don't really care. Everybody has an opinion. But if you don't have something to back up that opinion with some kind of reasoned frameworks and that draws on, either a question that you pose, your students pose, or being able to take a look and say, here, in this particular primary source, I'm going to draw this out and I'm going to be able to prove my point, and answer that question because, I have the ability to do that. And the driver is still the question. Okay, so again, that goes back to speaking, writing, etc. Okay, next. Okay, so again, I'm just going to hammer away at this essential question. And again, if anybody's, needing some additional, we may need some extra time, not tonight, but at another point. I think the most important thing that you do to your class and do in your class and prior to your class, is to develop that comfort level with being able to develop, a single essential question, multiple essential questions that are going to really drive your students. Learning sometimes is very uncomfortable. You ask somebody a question, and a lot of times people are assuming they know the answer. But when you pose that question in face-to-face situations, it's like, well, yeah, oh, okay, I thought I knew the answer, but I don't, and I need to maybe rethink what I thought I knew, and now I got to look at something, to justify my original position or change my position. That's okay too. There's no problem with that. Okay, if we could go on to the next. All right, and again, teaching for thinking, that's going to lead to all of these decisions. I mean, and again, we'll see this in a second. Okay, I'm going a little bit faster than I would want, but that's okay. Primary sources. You don't know what you don't know. Sometimes, John and I just had an opportunity to sit down again with a scholar, not just Bruce. We've been able to sit down with a number of scholars talking about the issue of immigration and talking about the issues surrounding race and racism. And I don't want to get too much off the track, but the ideas that we started with, we saw right from the very beginning, what we thought we knew, we didn't. There's a lot more, to race and racism. It's not binary. It's very complicated. And the scholar we worked with, drove us to, she asked questions and then drove us to think more and more about the subject and drill down. And, by the time we finished, we were a lot more in detail than we thought we would be, when we started. But that's okay. Again, like I go back, Gilder Lehrman is a resource provider. So the resources you can use. If you want to modify something and adjust something, that's fine too. But at least you have the platform to start, to be able to use all those things that you need to use or can possibly use in your classroom. Okay, I think there's just a couple of more things here. All right, we're going to talk about graphic organizers, and you'll see this in a second. I don't want to talk too much, more about that because I think we have, again, reading, reasoning, speaking, writing as the end result. And then I'll just show you two examples. Okay, I think of what's coming up are some, the bottom line. Okay, again, the idea of, you're going not just through facts and information, but you're having students explore and most importantly, engage and then explain, through the mechanisms that are provided in the lesson plan. And then an evaluation piece, for you and for them, for your students, not just, well, I got a whatever on as a grade, but more importantly, did I learn anything? All right. Did I learn anything at the end of not just the day, but, the whole of the unit that we're looking at? Okay. So let's just go a couple more slides. One of the examples, and we'll get to this, we're not using this one, but keywords, and I'll talk about it just briefly in the sense that it can be used as an example of an extension of one of the things that we're doing. The other graphic organizers, I think if we go to the next one, we're going to be actually using this one a little bit in one of the things that Bruce has written that's incorporated into our lesson plan. And then the next one, we'll have an opportunity to use this graphic organizer. And I think Martha has placed that in another framework, which we'll have an opportunity to do very shortly with regard to an exercise drawn from the material we're going to look at right now. So having said that, I think that's the end of the presentation. I lied. All right. There are two different organizers that I'm going to give you an opportunity. So one of the things about the lesson plan, it has a visual component, it has a textual component. I noticed a lot of folks in the audience are AP teachers, so you may deal a lot more with text. But in my 35 years of teaching, I taught everything from special ed to AP. So, and again, at the end of my teaching career, I found that increasingly, people were going to use and more comfortable with visual material. So we've incorporated some of those things and just as suggestions into what we're going to present and prepare and share with you right now. Okay, I think that's it. I am right. Okay, so let me just stop there. Anybody have any questions? I don't know if I went off base by just giving you the rationale, but everybody should have a link now to, let me do this. I almost did the wrong thing. Let me share my screen one more time. And you should have a link to this, right? The lesson plan. Does everybody have that available? You can unmute and just let me know. Yeah, I've got it or I don't.
Can it be put in the chat box again, please, Ron?
Okay. Martha, is that possible?
Yep, I will link it again, no problem.
I filled out that form already, though.
Okay, no, we're gonna jump back and forth. I just wanted to make sure that everybody sees, what I'm talking about. So obviously, teaching civics through history, focus on freedom of speech. All right, so real quickly, you can see if you've opened this particular link up, right, and you have it in your Google link, you can open it up. So, the introduction, fairly simple. Again, suggestions. It's not prescriptive. It's something if you had to modify it, that's fine. But I want to show you that there are, 5 different units or 5 different lessons inside this unit. And that ultimately you're not only providing content for students, that's the first 2 parts, but then you're providing some contemporary parts to the lesson, which allows your students to engage in a spectrum, okay, conservative, liberal, and somewhere in the middle, resources that also connect back to the materials that they're just engaging with for the historical perspective. All right. So with that in mind, you could see a whole bunch of things, with regard to objectives that you want students to demonstrate an understanding of a scholarly article, in this case, written by Bruce, okay? You want students to be able to identify and analyze primary sources, and you'll see what they are in a second. Draw inferences, by way of, being able to summarize in their own words, what the particular primary sources are all about. compose summaries in terms of a point of view, compare and contrast proposals by different writers in terms of the court cases in the way that they are decided. Develop a viewpoint, and present it in class in either written or oral form. I mean, a whole bunch of things. Again, what you want students to engage with. You want, again, what's driving this is student interest by way of, asking the questions that are going to excite them. And, again, you'll see in a second. Those are the essential questions that I was talking about, but they're not the only essential questions that you can ask. You notice a lot of these questions deal with wartime because in the cases that as Bruce pointed out, or as were decided either in early America by way of the 1798 Sedition Act, in later points in time, the things that happened in World War I, the things that happened as a result of World War I, in terms of America's confrontation with communism, and the way that it was interpreted, that there was issues of free speech that were involved. World War II obviously raised a lot of issues with free speech, and it continued into the Cold War, obviously. So again, wartime is a driver for a lot of the experiences and a lot of the decisions. And then that raises another question, Bruce. I don't want to get too far off base, but maybe later on when I'm finished, this is something. I mean, some people talk about we're in a forever war right now. Okay, so since 2001, Dexter Filkins, is a writer, but he's kind of coined the phrase, which probably is pretty accurate. We're in a war, and again, people don't even know we're at war sometimes. But the application of free speech issues may also be, part of that framework or that that thought process that puts us in a forever war. But I'm throwing that out just as something to consider and maybe ask a question about. All right, but again, for purposes of the lesson, you can see this is lesson 1, and I'm just going to walk you through it. The first, obviously, thing that here are materials. You can see not only the first, but the 14th Amendment, because a lot of times, very importantly, is due process, and that concept is applied, to many of the cases and all of the cases that we're talking about. But then you could see that there are other documents here, some of which Bruce has talked about. We're going to talk about Schenck in a second, because I want to use that just as one example. But the other, the other documents, the Whitney decision, the Brandenburg decision, these are things that Bruce alluded to, but I want to show you that they're here. And oh, by the way, let me just have somebody, and it could be raise your hand or don't jump all in at once, but how many people actually use Whitney now? How many people use Brandenburg now? Are these cases that you're already familiar with, or are these cases that you're not so familiar with? Let me just throw that out as a quick question. Liz, I'm looking at you. So you just happen to be on my screen. So are you using that in any of the cases now?
The Brandenburg.
You do? Okay. All right. Anybody else using any? Is there anybody who's not familiar with any of these? I mean, that's the other part. We don't know. And when John and I sat down with Bruce, we looked at a framework, and we're going to talk about that in a couple of seconds too. I just want you to be familiar with what we have here. Again, obviously you didn't see this material until just a few minutes ago, so it's kind of more difficult, and for other purposes, we were, if I was doing this in a different context, we'd probably have you break up into groups, okay? And the groups then would be able to take a look at one case or that case, this case, and then come back and talk about, what they found, what they were able to read, what they were able to digest, what they were able to, again, construct in terms of that thinking process that we talked about in framework. So, again, with that in mind, you could see these are, again, suggestions. Again, every one of the units, again, it's a suggestion, and you can modify this as you want, but, you by displaying the essential questions, starting with the historical background, I want to make sure that everybody knows that in this particular lesson, there are going to be 2 essays, one that goes with lesson 1, one that goes with lesson 2, both written by Bruce, and both which, frame the content of particular issues that are raised by all of the things in free speech. And again, I'm going to go back in a second. I mean, just talking about, the Whitney case or the Brandenburg case or the Chapinski case. I mean, very importantly, raising issues that your students may not be familiar with and that you want to, have them engage with in terms of those essential questions, and then being able to dig down into the primary source to be able to, to answer, and to evaluate and ultimately make a decision about in terms of the documents. So again, you could see each one of these, and again, I'll just unpack, each of the 2 lessons here. So again, we're going to do the cartoon activity in a second, but each one of these, again, documents raises questions that go back to the essential questions and that are provided to you with the intent of you having either the students, obviously you could do this with an individual student, everybody read individually. You could do it in pairs, or I think the preferred method with this particular kind of exercise is in the group activities. All right. So with that in mind, I'm just going to scroll through, the fact that there are first 2 content pieces to this lesson plan. Lessons 3 and 4. This is where I want to just draw your attention to something, because ultimately all of these lessons go someplace, and they go to having students hopefully engage in a civic action project. So again, providing the historical content through the mechanism of being able to look at probably 10 to 12 cases, 2 historical secondary source essays written by Bruce, and then leading to this, where the teacher has the ability to bring their students to all sides. It's a program that, again, we've contacted. They've continuously updated on their site materials that deal with free speech, materials that deal with immigration, materials that deal with race, materials that deal with voting rights. And again, from 3 different points of view. I mean, that's the point. To be able to provide your students the opportunity to say, okay, let's look at some contemporary secondary, periodical literature in which different points of view are expressed, be it on the right, the left, or the center. And all of these things then allow for, and again, a continuing discussion of whatever it is that you want to really have them focus on. And you might, create some additional essential questions at this point. In addition to the ones that we framed, you might say, well, I want to take it also in this direction. And I've got 2 or 3 other essential questions that I want you to do. And then lastly, ultimately a civic engagement project. At what point, and in a variety of ways, we would leave that to the teacher, but we've put some suggestions in here. Well, what can we do as, this is teaching civics. Well, civics is all about citizenship. Citizenship is all about participation. What can I, as a member, I'm not a subject, I'm a participant. I want to be able to have my voice heard, and I can do this in X, Y, or Z, things that you are going to be able to discuss with your students and be able to, at that point, have them go out to the community. I know COVID is causing some issues now. It's kind of put a damper on how realistically you might be able to do that. But again, when we're beyond this COVID issue, hopefully, in the next school year, you'll be able to think about these things and frame, well, I've got some resources here. I've got some frameworks here. I've got some, possible suggestions in order to, I'll be able to accomplish all that. So with that, I'm going to backtrack just a bit, okay? And I'm going to also stop sharing. Okay, so at this point, I'm going to stop for a second. All right, I talk too much, but that's okay. But if you've got questions, jump in here. And if you've, I know that was kind of a quick introduction, but I know you're going to have opportunities over the next couple of days to take a look at that material in a little bit more depth. I'm going to circle back to one specific activity that I do want us to engage in. But with that in mind, think about the reasons why we've contextualized what we've done in the lesson plan, what we've done in terms of being able to provide the opportunity for students to engage, okay, and that's the most important thing. Question, engage, and then ultimately that leads to the importance of learning. So any thoughts, reflections, comments?
Ron, I have an unrelated question.
Okay, that's great, Lois.
Yeah, you know my voice. This summer, I heard a really interesting question to one professor. I was wondering if Professor Bruce Allen Murphy has an opinion on this. Who would be on his perfect Supreme Court if you went throughout time? Who would be the top the top guys that you would put in. I just bought a biography on Louis Brandeis, so I'm really kind of hoping that you say him, but maybe not. I know it's unrelated, but I think that's kind of something fun that kids, it gives me a starting point as a teacher to know who, you know, you think is great.
Oh, I think you're muted, Bruce.
Told you, I never do that, Martha. I'm not sure if you're asking who is my favorite justice, or if you're asking if I were composing a Supreme Court, who would I like to see on that Supreme Court? So I'll answer it both ways.
Good.
I've become more and more fond of justices like John Paul Stevens, David Souter, and John Harlan II. Justices who are somewhat in the middle and who are pure judges. They look at the cases, they decide based on the merits and their concepts, they write very well, and I think you get a fair interpretation of the issues from justices like that. And I've often thought in my career how unfortunate it has been that the Senate has changed and become more political, and the confirmation process has become more politicized. I would have loved to have seen a court with both Robert Bork and Lawrence Tribe on it, the very best minds in constitutional law competing with each other. I would have loved to have seen a court with Robert Bork, Lawrence Tribe, and Antonin Scalia on it. I think you would really have gotten a fabulous analysis of the questions that the court has faced. But it's not possible because of the way the confirmation process has changed.
Well, no, thank you. And I want to do one thing before we leave. Martha, could you pull up our last thing? And this is the visual component. And again, I throw this out and I want to have you take a look, you know, because again, the visual piece, the organizer piece, I want to see if we can, you know, have some feedback from you. Oh, that's not okay. So, okay. We need to go to, so this is a summary of sorts, and also a platform, you know, for us to take a look. So over the course of the last, you know, couple of hours, we've been talking about freedom of speech, and I've tied some things here, and this goes back to true and untrue as well. So some of the answers that you might have thought, well, I thought that answer was true, or I thought that answer was untrue. You know, freedom of speech includes the right. It is, you know, included in the right not to speak specifically, you know, the right not to salute the flag. All right, that comes from the Barnett case of students to wear black armbands to protest, you know, in this case, the Vietnam War, the Tinker case. They use offensive words. I won't get too deep into this, but it's a very interesting case if you want to pursue it. You know, the Cohen versus California case. To contribute money under circumstances to political campaigns, the Buckley versus Vallejo. I don't think that's included, but I'm just throwing this out as are things that you might want to, you know, take this as a platform and expand on. To advertise commercial products and services with some restrictions, you know, the pharmacy case in Virginia. To engage in symbolic speech. Well, that's a lot of different places, to include, most importantly, the Texas versus Johnson case. All right, the next slide on that. Freedom of speech does not include the right. And again, to incite actions, we know that we talked about the Schenck case. I was going to come back to that, but I think for purposes of time constraint, we're going to, you know, skip that. But you can take a look at Bruce's, you know, suggestion in his essay in lesson 2. And again, all these other cases, I think, you know, all of which, some of which, or I should say, relate to school-related activities. And I think if that's where you want to bring it, you know, to talk about something like, you know, the Morse case, or to the Bethel school case, the Hazelwood case, I'm working backwards, you know, and obviously the Tinker case, you know, but those things all relate to things that your students are most familiar with and may be affected by. So that's, you know, very important. But I want to do this, and you have this in your Google Drive, I believe, right, Martha? So you can pull this up so that so as I'm speaking, you can also take a look. So I put 9, and John, I shouldn't say John and I put 9 political cartoons. We reached out to contemporary political cartoonists, Adam Zeigler and, Ed Hall, Jimmy Margulis. These may not be household names, but I'll tell you, if you have a follow-up question with me, my biggest thing is how accessible all of these contemporary political cartoonists are. So let's pull up the first one, actually, because she's one of my favorites. All right. If you're not familiar with her, Sidney Wilkerson, who draws and has drawn for a long time for the Philadelphia Inquirer. But I mean, this was going to be something I was going to use in the beginning, but if you could take a look, free speech, take a look at the figures here, take a look at, some of the action. In fact, what I want you to do when we get through the 9 cartoons, I want you to take a look, take a few minutes, use either one of the 2 organizers, the political cartoon organizer or the 4-quadrant organizer. And then if you could pick 1 or 2 of the cartoons, tell me why you find them the most compelling. Would you use all, some in the classroom? This is part of the pedagogical. I know we're putting you on a spot in a very constrained time period, but let's just look. Sidney Wilkerson, that one. This one by Ed Hall. Whoops, don't go too fast. Ed is number 2. Okay. Again, an issue that's old and new, by the way, right? So Colin Kaepernick versus, some of the other issues that have been, surfaced over the last couple of weeks in terms of American history. But, Ed Hall, again, all these guys and women are Pulitzer Prize winning political cartoonists. And again, the intent, like Plato, to be a gadfly, to get you to think, to get you to, get your blood boiling and maybe, or just your thought process going, and then being able to express, something in terms of that issue of free speech. All right. So if we're going further, we're going to go Jimmy Margulis, democracy rests on pillars, the pillars of the press. Okay. Number 3, number 4. Okay. Again, Matt Worker, another, big voice. I think these are 2. Well, Adam Zeigler. Keep going. I mean, if you just go, you have access to these. Okay. Go through the 9 cartoons and then go to the last slide, Martha. We're going to just look at the 2 organizers. Okay. Angelo is a Philippine writer. So if you take one of the cartoons, but take the one you think is most appropriate or compelling to you at this moment. If you would take a look, what's the significance of the central figures? What actions taking place in the cartoon? What makes it compelling for you? What's the mood or tone of the cartoon? And what message do you find most important in terms of, what the author is doing? Okay, if you could do that. Or if you don't want to use that organizer, and again, remember we talked about engaging and thinking. If we can go to the second organizer, and you've got access to both of these. Is there one more? I think. Yep, that one. Okay, details, descriptions, and decisions. So, I mean, either or, take one of the organizers and use it to make a decision about one of the particular images, and then let's have a quick discussion of what you found most compelling. I'll give you a couple of minutes to do that. And if, as you're finished making your decisions, as you're finished making your notes, just put in the chat, yeah, I'm ready to go.
Can I ask a question?
No. Yes, of course.
I just want to be clear. The link that we've been getting has been the link to the sign-up sheet, which means that the drive that these are in will be emailed to us. So
yes,
there's
other material. Yeah.
Have them yet?
You don't have them yet.
Is that correct?
We don't have them yet.
Correct.
You don't have the nine cartoons.
Yeah.
Let me link it again for you. I think
the cartoons are in that download for the free speech, pages 70 through 78.
Oh, yeah. What am I thinking? They're also in the lesson plan. All right, I thought there was a separate one. But if you're having difficulty finding this now, yeah, they are also in the lesson plan. Thank you.
Okay. Thank you.
Okay, well, some people are going to start to, I see, answer. Lois, you've said something about the satire cartoon. Do you want to unmute
Yeah,
yourself? Yeah.
You know what I'm thinking about, Ron, is if you look at that cartoon, you could use that cartoon to analyze the other cartoons. Like the first thing you ask kids is, what stings you about this? What annoys you about this? What is it trying to teach you? What does it inform you about? How does it ridicule and what does it expose? What kind of truth? I was thinking that could itself be how you analyze the other ones.
No, good point. I mean, again, if you don't know what you don't know and you don't think about what you haven't heard from somebody else, which is good. Okay, so thank you. Anybody else have something that, that jumps out at them, a particular cartoon and a reason for finding it compelling? Here's another question. I mean, a secondary question. I don't want to overload you with too many things. Would you use one more, a few, not all, whatever. So, and also which one would you start with? So how we doing? Okay, Kaylin, you want to unmute yourself? Let us know what you think. I see you're talking about pillars of democracy.
Yeah, I was just thinking about that one in relation to news sources that promote like conspiracy theories and obviously fake news and things like that. And how well do those pillars hold up our democracy when what they report is entirely inaccurate, like provably false?
Mm-hmm. Okay, no, that's great. Would there be another? Is that your favorite? You'd use that one, or would you? Just this goes for everybody. Is there another one that you would use as well, or that was your favorite?
I mean, that was my favorite. I don't teach government, so.
Okay, no. I'm put you on the spot. Okay, JB, I see you're in there.
There we go. I liked 1 and 9 both, Ron, because they kind of cover the same subject, but when you're dealing with, in my case, 17-year-old kids, they have to learn that freedom of speech covers speech you don't agree with.
Mm-hmm.
And it's really important to learn how to process information and either accept it or reject it, or let it, change your mind or not about things. But, they have to learn how to agree to disagree. And that's why I kind of picked those two.
Okay, no, all right, great. Emily, I see you're in there.
Yes, I was thinking, especially with some of the conversations about free speech earlier tonight and thinking about the January 6th events, with my students, a lot of discussions came up about like the comparison between Black Lives Matter protests of the summer versus like how rioters were treated at the Capitol last week. And, I think this cartoon goes a lot with that issue of, free speech and the impact of like racial bias on free speech and freedom of expression, or like freedom to protest and assemble. So I think there's a lot of good discussion points there.
Okay, thank you. Amber, you came up? Or you just had an agreement? I'm looking at my screen real quick. I don't know if, if I look too quickly, I'm sometimes seeing that people are just in agreement with people. So, okay. I don't see any other folks, and that's okay. At this point, I just wanted to introduce, unpack, give the overview, provide you an opportunity to see, what we've produced in terms of the program for teaching civics. Well, I don't know if there's any follow-on points, but I thank everybody for your participation and your attendance tonight. Bruce, thank you so much for helping us out. I mean, and again, pointing us in some directions. I want to also point out, a lot of what Bruce said regarding many of these issues are in the secondary sources that are part of the lesson plan. So you've got, a secondary source written by Bruce in lesson 1. You've got a secondary source written by Bruce in lesson 2. And most importantly, for both of those things, and again, this would be at your discretion to do with your students. There's an organizer that would be available, for students to be able to read, the particular section. And then, you're asking the students if you can have them either in small groups or, pairs or individually, what are the 3 most compelling statements in any document? It might be in Bruce's secondary source. It might be in, one of the court decisions. And again, the court decisions are both, majority and minority opinions. And oftentimes, you might be able to want to explore that. So we covered kind of a lot of ground, but, unfortunately, time constraints and, the fact that we can't break into small groups, I think, inhibits us a little bit. But I think, the takeaway is to be able to digest what we've done this evening and, with follow-up questions as necessary. So I'll turn this back over to Martha.
Yes, thank you so much to Bruce, to you, Ron, Zach, David. Thank you for letting us at GLI come and present at this awesome conference. Thank you all for joining us and participating. It's been such a great discussion. And I know I've learned a lot, especially after taking that quiz and not getting many answers right. So I really appreciate you all being here. Just in terms of next steps really quickly, please make sure you have signed in on that sign-in link. I believe David just put it in the chat as well. That way you will be able to access the Google Drive that I've set up with that includes all the resources that we've covered today. You also will be getting access to the TCTH website that Ron talked about earlier as well. So make sure you sign in and with your name and your email so we can get you that information and get you access to the website. And thank you again to the Sumners Foundation for continuing to support history education and here at GLI so we can make this happen. So if you have any additional questions, please email us at education@gilderlehrman.org. Thank you again, guys.
Oh, thank you. Okay. Don't forget, history equals historia equals inquiry equals, a whole bunch of things. So anyway, okay. Thank you so much.
On behalf of the Oklahoma Council for the Social Studies, we thank everyone for being here today. Appreciate Gilder Lehrman for their great expertise. So thank you all for joining us.
Thank you, David, for having us. And thank you, Sumner Foundation, for making this happen. So
stay well, everybody.
Okay, take care now.